Here to introduce our next speaker is Greg Kafoury. And it is no accident that Greg is going to introduce Joe McMahon, because Greg, who is an outstanding lawyer from Portland, Oregon, has tried hundreds of cases and won verdicts for activists, whistleblowers, and victims of police brutality totaling more than $21 million. He's a graduate of the Hastings College of Law in San Francisco, and I love this, was unanimously named Distinguished Trial Lawyer of the Year in 2018 by the Oregon Trial Lawyers Association. Unanimously. Try to get lawyers to agree on anything. They agreed on Greg. Ladies and gentlemen, Greg Kafoury.
For those who wish to sustain a system of great economic inequality, our present system of policing works well. For those of us who hope for and believe that we're on the cusp of major change in the field of economic justice, looking at major steps to reform policing should be high on our agenda. We start with a culture of brutality. American police departments are dominated by a culture of brutality, which means the early resort to force, the unnecessary use of force, the excessive use of force. We see this creates in large swaths of the population distrust, hostility, fear. So, the result, refusal to cooperate, reluctance to cooperate with police, crimes going unsolved. And as both sides become more isolated, this system yields a cycle of oppression and resistance. The culture of police brutality is sustained by another cultural trait, which is police solidarity. Observed misconduct of one officer by another goes unreported. Officers cover for each other. They are expected to cover for each other. This is called the thin blue line. An illustration of this culture of brutality and solidarity comes from my hometown in Portland, where I practice law with my son here, Jason Kafoury. There's a guy named James Chassie, a sad, marginal guy, chronic schizophrenic, and the police suspected him of the most trivial of offenses. He was confronted by the police. He ran away. A man as scared and harmless as a rabbit. And he was tackled by police. Several civilian witnesses testified that Sergeant Kyle Nice kicked Chassie repeatedly in the ribs with his boot while the man was down and helpless. Chassie died there, face down in the street. 27 fractured ribs. The observing officers, and there were many, denied they saw any such thing. Sergeant Nice was briefly taken off patrol during the investigation, such as it was, and after he returned, a fellow officer saw him in an encounter with some homeless, vagabond street musicians, and that officer made an issue of the fact, he said, Sergeant Nice is not ready to be back on the street. Man is not okay. Well, Nice went back on the street, stayed on the street, but the man who reported him, the officer who reported him, became the first Portland police officer to go from patrol to working in the evidence warehouse. Brutality and solidarity. The structure of our police forces is a military one. And we think that, I believe that these tendencies toward brutality and solidarity arise from and are sustained by the military structure, the military-style organization of the police departments. This is a structure designed for warfare. This is a structure. My Marine friends tell me that if soldiers are confronted by a well-designed ambush, their instinct, of course, is to flee. But their best chance of survival is to go straight at the point of fire and to overcome it. So, when you're dealing with war, military-style discipline is required. And in our cities, I believe specialized police forces, tactical squads, will sometimes be necessary. Rare occasions, but we should not view our cities as battlegrounds. These highly authoritarian military-style structures attract people who have authoritarian personalities. In my years as a lawyer, I can tell you that those who are unjustly brutalized by police tend to be those who challenge the officer's authority, or who sometimes simply are insufficiently deferential. We should end the militarization of our police forces. And rather than forcing upon our officers a system designed for getting frightened 18 and 19-year-olds to kill other people, we should treat officers as the serious professionals that we want them to be. We want to attract those who are drawn by a desire to protect and serve, not by a desire to intimidate and humiliate and dominate. Let's get rid of the militaristic uniforms. Why can't police officers look more like us? We should end the dead hand of internal selection and seniority. Why not allow police officers to pick their own leaders? Let them figure out how they should be organized, how they should be led. Reforming police is enormously difficult. It is a long-term project. And, of course, their power is enormous. District attorneys, judges have great fear of being opposed by police organizations. In my hometown, no police officer has lost their job for the physical abuse of a citizen while they're on duty. In living memory, no police officer has been prosecuted for the physical abuse of a citizen in my hometown, in living memory. Our firm has a singular record of obtaining successful verdicts in police cases, and there is a role for civil litigation. But perhaps the greatest hammer against individual police abuse, the one which can do the most to deter it, is represented by the unique success of our next speaker. Joseph McMahon, the elected state's attorney for King County, Illinois, obtained a conviction for murder against a police officer who shot a drug-addled man who was walking away some 16 times. It's quite a story, and he's quite a guy. Ladies and gentlemen, Joseph McMahon.
Well, good afternoon, and thank you. I appreciate the introduction. Let me start with thanking the organizers of today's event, but also the plaintiffs' bar for the work that you do to preserve our civil justice system, our jury system, because as I'll talk about this afternoon here in just a couple of minutes, that really was one of the key issues in the case that we put together against former Chicago police officer Jason Van Dyke. October 20th, 2014, about 9:46 p.m., the Chicago Police Department get dispatched to a truck yard on the southwest side of Chicago for somebody in a truck. That's what started this event. About 14 minutes later, Laquan McDonald, a 17-year-old African-American boy, shot dead in the middle of Pulaski Avenue 16 times by an on-duty Chicago police officer. 14 minutes between the 911 call of somebody in a truck and the death of a 17-year-old young African-American boy from Chicago. Very quickly, a very powerful and convincing narrative was advanced by the Chicago Police Union. An individual by the name of Patrick Camden, anytime there was a law enforcement incident, anytime there was violence in the city of Chicago and somehow the Chicago Police Department was involved, on the news that night we would see Pat Camden explaining the version of the police. And Pat Camden very immediately, very early, advanced a narrative of a wild, crazed, out of control man with a knife attacking the Chicago police. And that Jason Van Dyke did the only thing that he could do to stop that, and I'm quoting, that crazed individual from harming Chicago police officers and harming citizens of the city of Chicago. Much of the incident was captured on videotape. Some of it dash cam video, some of it surveillance video from nearby businesses. And because that very strong and convincing narrative was advanced quickly by the Chicago Police Union, initially the shooting, while it was shocking, it was not the only shooting. And it certainly was not the only death of a young black man in the city of Chicago during that time. So while it generated a significant amount of media attention, that media attention evaporated fairly quickly. Over the next 6-7 months, this narrative started to unravel. There were individuals, to the Chicago Police Department's credit, there were individuals from the Chicago Police Department who had witnessed or had observed the videotape that captured the shooting, had observed some of the other video surveillance that was recovered from the event, and information started to leak out to members of the media that, hey, maybe this shooting wasn't exactly as it was described by Pat Camden and the Chicago Police Union. An independent journalist filed a Freedom of Information request for the video. At this time, there had been no police discipline imposed, not only on Jason Van Dyke, he had been placed on administrative leave. It's kind of standard practice anytime there's a officer-involved shooting. But he had not been fired, and none of the other officers, and I'll get to the number of other officers that were on the scene that night, were disciplined. The independent journalist files his, what we call a FOIA, Freedom of Information Act request for the video and for the reports, and the city of Chicago opposes that. They opposed that for a long time. That eventually turns into a lawsuit filed in the Circuit Court of Cook County. And in November, so 13 months later, a circuit court judge orders the Chicago Police Department to release the video and all reports surrounding the shooting of Laquan McDonald. Now, the shooting occurred October 20th, 2014. We're now a couple of days before Thanksgiving the following year, 13 months later. The city braces for, the city has seen the video. Obviously, they know what occurred. The city begins to brace for what they think are going to be large-scale demonstrations once the public sees once the sunshine of publicity in this video is released. The video is released. It does, in fact, generate significant civil, orderly protests, but to the extent that they're orderly, and for those of you that are familiar with the city of Chicago, its main kind of shopping district, and again, this is the days before Thanksgiving and right around Thanksgiving, very busy shopping time. But the protests shut down Michigan Avenue, which is the largest shopping district in the city of Chicago. Hundreds and thousands of people march up and down Michigan Avenue. They close stores on the day after Thanksgiving because patrons can't access those doors. And about 3 days later, the Cook County State's Attorney files criminal charges against Jason Van Dyke, which in many people's minds furthers this idea that there was a cover-up, that initially there was a cover-up by the Chicago Police Department that continued for 6, 8, 12, 13 months, and but for the release of this video, through the insistence of this independent journalist, there would have never been criminal charges brought against Jason Van Dyke for shooting and killing Laquan McDonald 16 times. That's compounded, that skepticism is compounded by the fact that there is a historical pattern of discrimination by members of the Chicago Police Department against minority members of the Chicago community. City of Chicago and its police department has operated under a number of consent decrees for years, for decades in fact, that are imposed and monitored by federal courts. So really what is taking place here is a storm that is getting ready to probably take down the city, the mayor of Chicago, the then mayor of Chicago, Rahm Emanuel, who then chooses not to run for re-election. Following the Cook County State's Attorney's decision to charge and presenting the case to a grand jury, there are calls for both her resignation and that she be disqualified from prosecuting the case because the allegation is that she's part of the cover-up. And that's not going to be the focus of my comments here today. Let me just say that both the United States Department of Justice, immediately after the shooting on October 20th, 2014, and the Cook County State's Attorney's Office did conduct a joint investigation that was moving way too slow. I know that now, and she knows that now with the benefit of hindsight, but there was an investigation that started by the Department of Justice and the Cook County State's Attorney. But nonetheless, the perception and the appearance was then that she was conflicted. She was part of the cover-up. She opposed the removal of her and her office from the case for a period of time, and then eventually agreed, which set in motion my appointment by the court to step in and prosecute this case. That occurred in August of 2016, so we're almost 2 years after the shooting when the ultimate prosecutor who is going to try the case and investigate the case, myself, was appointed to come in and analyze the case, put the case together, make decisions about what the charges should be, and really what I and my team did. I put together a team of 4 other lawyers. We really dug our sleeves up for the lawyers in the room and for all of you that take on a big project. You roll your sleeves up, you dig in, and you analyze the facts. You analyze what happened, because ultimately I had to make a decision about what should the charges be. Were the murder charges appropriate? Mr. Van Dyke was charged with multiple counts of murder, official misconduct, and as we really delved into the facts of this case, part of the process that we went through was looking at other police shootings around the country. And so I met and I arranged meetings between my team and prosecution teams from all over the United States. We met with the team from Ferguson, Missouri, that analyzed the shooting that occurred in Ferguson, Missouri. We met with a team of prosecutors from North Charlotte, South Carolina, who prosecuted an individual who fled a traffic stop, a simple traffic stop, was shot 7 times in the back, and was ultimately charged with murder in Charleston, South Carolina. And that jury was unable to reach a verdict. It was a hung jury. As you all know, the Ferguson situation resulted in no criminal charges whatsoever being filed against that police officer. But we went through that process. And the reason we did that is because there are inherent kind of system obstacles or challenges to prosecuting police officers. And I would kind of break those down or categorize those as kind of 3 separate categories. There are system obstacles, there are legal obstacles, and there are political obstacles. And they were touched on briefly just a couple of minutes ago, but let me just kind of dig into that a little bit deeper. There are system obstacles to prosecuting a police officer for an in-the-line-of-duty shooting because inherently across our country, in Chicago, in all communities, there is a level of public trust for our police officers. Now, we all know that that is changing and that is evolving, and we expect our police officers to act and police us differently. But if you go back to the founding principles of law enforcement in this country, they're modeled after this individual who was the Prime Minister of Great Britain, Sir Robert Peel. And he essentially espoused 9 principles of policing. And the one that I think is most appropriate is that it's time for us to remind ourselves, and it's time for us to remind law enforcement that we as a community, we set the standards for law enforcement, and we give to law enforcement the authority to police us. So we need to set those standards. We need to set those expectations. But if you look historically over the last 10, 20, 50 years, and much longer than that, there is a level of public trust. And so we ask police officers to run towards danger. We ask police officers to protect us. They do get from most of our community the benefit of the doubt in a close case. And when we ask those police officers to risk their life, to protect us, they should get the benefit of the doubt in the close scenario, in my opinion. And so that's one obstacle to prosecuting a police officer. A criminal case involves proof beyond a reasonable doubt, a unanimous jury. We're selecting a jury here. Many people in our country, rightfully so, trust police officers and provide them that benefit of the doubt in a close case. We also have to recognize that I think there are obstacles to prosecuting police officers because of all of our own implicit biases that we have, our prejudices that we have, and then also our explicit biases as well. I can't talk about this case, the criminal case against Jason Van Dyke, and not recognize that there was some element of race involved in this case. Jason Van Dyke saw a 17-year-old black boy walking down the street who would not listen to police officers. Been repeatedly told to stop, repeatedly told to drop a knife, a very small knife that Laquan had in his hand. Primarily held that knife down to his side. But you had a white police officer telling a black boy, stop, repeatedly, and he didn't do it. And you have to recognize, I recognize that had to play a part, even though Jason Van Dyke and every other police officer on that scene absolutely denied that that race had anything to do with Jason Van Dyke's decision to shoot. It's just not a fact that I could ever accept. It had to be some factor in Jason Van Dyke's mind. There's legal obstacles to prosecuting police officers as well. State laws provide the right for a police officer to use some element of force when he or she is pursuing a fleeing felon. Now, we had a lot of disagreement in our trial about whether Laquan McDonald was a fleeing felon, but that was the narrative, that was the defense that Jason Van Dyke advanced. We had an individual with a knife, an individual who was observed in a truck yard where he was not supposed to be about 14 minutes earlier. And so there are obstacles such as our state laws that allow law enforcement to use force involving a fleeing felon. And then police officers, like all public employees, have certain rights when they're compelled to give a statement in their employment context. And that created some challenges as we put our case against Jason Van Dyke together, and the Chicago Police Department, the Department of Justice, and the Illinois State Police put this investigation together. Because Jason Van Dyke was interviewed the night of the shooting, but he was also compelled to give his statement in the context of his employment status to his supervisors. So while I had access to portions of his statement, I did not have access to the majority of his statement. And those are rights that police officers have that many of us private citizens who might be involved in a crime of violence don't enjoy. We don't have those protections. And then the third obstacle to prosecuting a police officer that I want to talk about really are just the politics of prosecuting a police officer. I'm a prosecutor. I work with law enforcement every single day. The vast majority of my cases that I prosecute come to me from one of, in my jurisdiction, 32 different police agencies, both state and federal and local police agencies. And so the idea of me prosecuting a police officer doesn't really resonate all that well with people who I work with every single day. Add to the fact that I, like most district attorneys across the country, we're elected by the public. And as I said earlier, generally the public trusts law enforcement. We want them to come when we call. We want them to help us when we're in trouble. We want them to help us when we're in danger. And so prosecuting a police officer, maybe it hasn't been the wisest political decision that I've made in my career, but the facts of this case demanded that justice be served, and I felt that this was a test of our criminal justice system and our court system. We're going to hold individuals who we accuse of a crime accountable, and we need to hold all those individuals accountable, whether he or she is a police officer, a gang member, a drug dealer, or some abuser. So let me talk about our approach. I gave you a little sampling of the facts. October 20, 2014, about 9:46 p.m., the 911 call. By the time the initial responding police officers arrived at that truck yard, Laquan McDonald had left. He'd walked away. There was a brief interaction between the 911 caller, his name is Rudy Barillas, and Laquan. There were some words exchanged. There was no physical confrontation. Rudy picked up some gravel, threw it at 17-year-old Laquan. That was enough to scare off Laquan to get him to leave. He had the knife in his hand, showed the knife, never threatened or never touched Rudy with the knife. But that little bit of gravel and grit and dirt, throw it at Laquan, was enough for Laquan to walk away. Laquan walks away. A couple minutes later, the first unit of the Chicago Police Department arrives. One officer gets out, talks with Rudy. Rudy describes where he went, up the street, made a right. Gets back in the squad car with his partner. They drive up there. They make a right turn, and there's Laquan McDonald walking down the sidewalk just at a normal pace. Officer gets out, begins to follow him on foot, and this starts the process of officer telling, this is Officer McGilligan, telling Laquan, stop, turn around, drop the knife. Laquan ignores him. He's 17 years old. He had an amount of PCP in his system. Laquan McDonald had kind of been in and out of the juvenile system for a lot of his life. Laquan had a challenging life. But he doesn't listen to the officer. They try to stop him. They try to use their vehicle to stop Laquan. That doesn't work. Laquan stabs the tire. It pops the tire of, it's a big police cruiser. You've seen these. It's a big SUV. Hits the windshield with either the butt of the knife or the pointy end of the knife, but never threatens either Officer McElligott or Gaffney, his partner, who remains in the car. And Officer McElligott testifies, he's asked, why didn't you shoot him at that point? He just attacked your squad. He attacked your car where your partner is inside the car. And he was asked, why didn't you shoot Laquan McDonald at that point? His testimony was, he wasn't a threat. He wasn't listening to us, but he wasn't a threat, and it wasn't necessary to shoot him to effectuate the arrest. So McElligott and his partner are calling out the facts. They're calling out the slow speed foot pursuit of Laquan McDonald. It progresses down towards Pulaski Avenue, which is kind of a light industrial area on the southwest side of Chicago. And by this time, additional police units are responding. There's been a call out for a unit with a taser. And by the time Laquan McDonald reaches Pulaski Road is a well-lit, it's a busy road. It's 6 lanes, it's residential, it's commercial, but it's late at night, it's October. It's a nice, warm night in October in Chicago. There is not a single pedestrian on the street in the area where Laquan McDonald is shot and killed. And remember, the narrative that was advanced by the Chicago Police Department Union was Officer Van Dyke shot Laquan McDonald because he was a crazed individual who was a threat to the Chicago police officer and the citizens and the community in that area. But the video didn't show a single pedestrian in the area. In fact, the video recovered from the dash cam showed a 7-foot chain link fence to Laquan's right. Laquan is walking down the middle of Pulaski Avenue. There are at this point 5 fully marked Chicago police units on the scene. Some are behind him, some are alongside of Laquan, others are approaching from the south towards Laquan. And they have essentially boxed Laquan in using kind of a semicircle tactic in their police units. And again, all of these vehicles are fully marked, equipped, heavy-duty police SUVs that you see in any and every major city across our country. Jason Van Dyke and his partner show up. Jason Van Dyke opens the door, steps foot on the road of Pulaski, or on the street of Pulaski Road, and 6 seconds after he is out of his squad car, fires his first shot, striking Laquan McDonald. He continues to shoot for the next 12.4 seconds, striking Laquan McDonald 15 more times, all 16 shots striking, hitting, killing Laquan McDonald all over his body. And when he emptied his clip, he dropped his clip, put the second clip in, drew on him a second time until his partner walked up and said, "Enough, I think we got this." That's how the shooting ended. When I inherited the case, or I was appointed to prosecute the case, Jason Van Dyke was already charged with first-degree murder. And as I met with prosecution teams across the country about how they put their cases together, our case seemed, I liked our case. I recognized the challenges of prosecuting a police officer, and that no other police officer in the United States has been convicted of an in-the-line-of-duty shooting, convicted of murder for an in-the-line-of-duty shooting. And so I talked to the other prosecution teams about how they went about charging and what they charged. And one of the decisions that we made was to add additional counts. We charged him again. I presented the case to the grand jury a second time after I was appointed. Mr. Van Dyke was again charged with multiple counts of first-degree murder, all kind of just different theories of the murder. But we made a decision to charge, in addition to the murder counts, 16 counts of aggravated battery with a firearm. And that generated both a good and negative reaction from kind of the legal community in and around Chicago. You know, he shot him, he killed him, why charge him with something other than first-degree murder or second-degree murder if that's what you think he did? And the feedback that I received, and this goes back to that public trust, was that there is an inherent resistance to find a police officer guilty of an offense with the word murder in it. And so one of my concerns was, my focus was justice in the case. And I felt that justice was charging Mr. Van Dyke with murder. I thought that's what the facts warranted. That's what I asked the jury to convict him on. But I wanted to charge him with everything that I felt he did, every crime that I felt he committed. And if I had a jury that was unwilling to come to a unanimous decision on murder because of maybe an implicit bias or favoritism or just the resistance to finding a police officer guilty of an offense with the word murder in it, I added the 16 counts as a backup. I didn't think it was appropriate. I was concerned about the safety and the infrastructure of the city of Chicago if Jason Van Dyke walked out of that courthouse not having been found guilty of any offense. So as we put our case together, that allowed us to get into a lot more details about the impact of every shot on Laquan McDonald's body, the damage that it caused, the location. There was extensive testimony from our medical examiner. Again, for those of you who are familiar with Chicago, this is not a good fact, but just the reality of the city of Chicago. But for about 4 years, between 2018 going back to 14, even a little bit more than that, there were more gunshot homicides in the city of Chicago than there were in the city of New York and the city of Los Angeles combined. So a fraction of the population, more gunshot homicides. So I felt I had the best expert in the country. She testified very convincingly about each gunshot, its location, the damage that it caused, and how all of those gunshots led to the death of Laquan McDonald. The other thing that I wanted to talk about is, this case and these cases across the country, they generate, rightfully so, intense public scrutiny because it is our police department who is on trial. In this case, one police officer, but it's our police departments who are on trial, their conduct, their official action took the life of a member of our community. And so I had to make a decision about, do I just put together a factual case? Do I play the videos? And for those of you that have followed this case or know anything about this case, you know that essentially all of the videos are now available on the internet. But I also had a lot of experts from the Department of Justice, and I had to make a decision about, do I want this case to be driven by the facts of this case, or do I really want to bring in experts on use of force and ballistics and video analysis? And ultimately, the decision was to do both. I thought the facts on this case were so egregious, and they certainly warranted the charges of first-degree murder and the additional counts that we added. But again, because of the turmoil, because of the emotion involved in this case, I had experts at my disposal. I thought it was critical that the jury hear all of the evidence to make a decision on whether or not this was first-degree murder and aggravated battery. So let me talk about how we presented our case. Our case was tried before a jury. This was also really the first criminal case brought against a Chicago police officer that proceeded to a jury as opposed to a bench trial in the city of Chicago. The vast majority of those charges that have been brought, when they've been domestic violence or certainly a lot, very serious cases, but much less serious than murder. The vast majority of them, in fact, all of them went to a bench trial, a trial in front of a judge, and the vast majority of those cases resulted in the finding of a not guilty. And so we litigated extensively both where this case would be tried and whether, not so much whether it would be a jury trial, because in Illinois that's the exclusive right of a defendant, But we litigated extensively where that trial would be held, and ultimately we hired experts on did we have the ability to select a fair and impartial jury. Again, there was more media coverage on this case. To give you a point of comparison, during the trial, the number of media hits to the Chicago Tribune's internet homepage set a record. Okay? The previous record was when the Chicago Cubs won the World Series after 108 years. So ultimately, we were able to select a jury. We brought in 200 jurors. It was really the first time that I participated in jury selection where we did individual jury selection and questioning. There were people who, as we brought them into the courtroom to conduct the voir dire and make our jury selection, literally fainted because of the pressure. Every media outlet, nationally, locally, internationally, was present outside the courtroom and inside the courtroom, and that put a lot of pressure on potential jurors. But ultimately, we selected jurors that were fair. We put our case on over 4.5 days. We started with about 115 witnesses, and we pared that down to 24 witnesses, the 3 experts that I mentioned on use of force, ballistics, and our video. And really what this case turned on, and you touched on it earlier about law enforcement. Law enforcement has the right to do what's necessary, and only the right to do what's necessary. And in this case, it was not necessary to shoot Laquan McDonald 1 time, and it's certainly not necessary to shoot him 16 times to effectuate an arrest for a relatively minor nonviolent offense. I think I'll wrap it up there. I'm glad to take questions. I appreciate the opportunity to be here. Thank you.